it's 3:30. We've got a lot to do, so let's get started. We have two bill hearings. The first one is Senate Bill 283. We'll open that hearing and have Natalie give us an overview.
Thank you, Mr. Chairman. Senate Bill 283 extends several of the healthcare provisions enacted to respond to the COVID-19 pandemic, and it also makes some changes to the immunity provisions for healthcare providers and persons conducting business in the state. Section 1 amends KSA 48963. That's the statute that allows certain physicians to practice telemedicine. Current law there requires an out-of-state physician to advise the State Board of Healing Arts when they're going to practice telemedicine, and they also are required to hold an unrestricted license to practice medicine and surgery in that other state. This section also is currently set to expire on March 31st of this year. This bill would allow those out-of-state physicians to practice telemedicine only if they hold a temporary emergency license, which would be granted by the State Board of Healing Arts, and it would extend those provisions until March 31st of 2022. Section 2 amends KSA 48964. That's the section that authorizes hospitals to admit patients in excess of their licensed number of beds when the hospital determines that that is necessary to respond to the COVID-19 pandemic. Current law there provides that that section expires 120 days after the termination of the state of disaster related to COVID-19, and this bill changes that so that it would expire on March 31st of 2022. Section 3 amends KSA 48965. That's the statute that allows the State Board of Healing Arts to grant a temporary emergency license to practice any profession that's regulated by the board for the purposes of responding to COVID-19. Currently, that section is also set to expire on March 31st of 2021. This bill would allow applicants for that license to practice in Kansas with that temporary emergency license upon submission of a non-resident healthcare provider certification form to the Healthcare Stabilization Fund. And it would also waive payment of the surcharge for those practitioners. And the section is also amended to extend those provisions of law to March 31st of 2022. Section 4 amends KSA 605503. That's the healthcare provider civil immunity provision. Currently, that section does not have an expiration date. I would note it is limited in its application by that retroactivity provision, which is in a different statute, but this section of law itself doesn't have an expiration date, and it would add one that would be March 31st of 2022. Section 5 amends KSA 605504. That's the business immunity provision for COVID-19 claims. Currently, that section is set to expire March 31st of this year. This would extend that to March 31st of 2022. And then finally, Section 6 amends KSA 65468. That is a statute that relates to definitions related to rural health networks. The definition of critical access hospital was amended in relation to COVID-19 to allow use of more beds, things of that nature. That is currently also set to expire. It actually, by its terms, would be June 1st of 2021. So this bill extends that to March 31st, 2022. And I can take any questions.
Natalie, Representative Carmichael.
Thank you. Ms. Scott, I received a question from a constituent, and I think I know the answer, but does this bill in any way differentiate between the immunities granted to for-profit versus nonprofit corporations?
Mr. Chairman, it would kind of depend, I guess, on what that nonprofit corporation does. If they had a different immunity provision applied to them, but no, as long as they're just a normal business conducting business in the state, then it doesn't differentiate.
Yeah, to be more precise in my question, assuming the businesses or healthcare providers or whatever are engaged in the same activities, I don't believe that this bill differentiates in the immunity simply because one corporation is for-profit and another is nonprofit. Do I understand that correctly?
No, especially on the healthcare side. I mean, because this bill has two different, it brings in the healthcare immunity provision and the business one, but neither one of them differentiate based on whether it's a for-profit or not for profit.
Thank you for your help. Thank you, Mr. Chair.
Any other questions for Natalie? Do not see any. We will move on to proponents, and first up is Eric Stafford.
Good afternoon. Thank you, Mr. Chairman and committee members. My name is Eric Stafford with the Kansas Chamber of Commerce, and appreciate the opportunity to testify in support of Senate Bill 283 this afternoon. So doing a little Groundhog Day here of back again with business liability, hopefully for the last time. This provision, I think we're Section 5 of the bill. Senate Bill 283 passed the Senate 31-8. This would extend the provisions that you all have extended several times now until March 31st of 2022. So intention, same language as before, not trying to really drastically change anything. I know there was some amendments added on the healthcare side. This bill just started on the business liability components, but when the Hospital Association was looking to get that amended, we didn't have any objection to that. So that's where the bulk of the new language comes from. So that's really it. You guys have heard this before. I don't want to belabor you to death over what we're trying to get done here, but appreciate the opportunity to speak again today.
Any questions for Eric? Representative Schreiber.
Thank you, Mr. Chairman. Eric, and maybe it's, I'm trying to decipher all the strike-throughs and the bold type. So when it's extended to March 31st of 2022, it looked like, at least on page 3 and beginning on line 8, it talks about expiring 120 days after the expiration of the current state of disaster. Was it changed to just a set date of March 31st for?
Yes, for the business provisions that we'll speak to, that would be section or page 4. And initially the original version of the bill was set to expire at the end of the emergency declaration. And then that was changed. The Senate changed it to Senate committee changed it to March 31, 2022, line 14 there on page 4. So the feedback after the hearing on the Senate side was, we'd like to have this go on forever. So would we, but in the world of perfect, they settled on, we were just asking for the declaration. They settled on March 31st, 2022, just to give a little bit more time. And so that's kind of how that evolved.
Okay, thank you. Thank you, Mr. Chairman.
Any other questions? Thank you, sir.
Thank you.
Next, we have Audrey Dunkel.
The challenge of a mask and glasses is always special.
I am
And I had
surprised I have not
earrings.
broken mine. A number of times I've caught it and my glasses fly across the floor.
Exactly. Well, thank you, Mr. Chairman and members of the committee. My name is Audrey Dunkel, and I'm the Vice President for Government Relations for the Kansas Hospital Association. And we're here to speak in support of Senate Bill 283, and I think we've already had a question. As Mr. Stafford said, we added a lot to this bill beyond the business liability because we did ask for the inclusion of hospitals to have their liability covered through the March 31st of 2022. So not just action specifically during the state of disaster emergency, knowing that we could still be facing over the next year surges and things that might happen, that even if the disaster emergency expires as of July 1st, we may still be addressing some of those issues. The other provisions then that were included, we looked at Senate Bill 14. We appreciated the extensions there. We went back and looked at it and said, okay, if the state of disaster emergency ends, what are the things that we might need to be able to do quickly? Should we have surges in certain parts of the state? Knew what challenges our hospitals had faced before, and asked for those to be included in here. So in addition to the liability, there's the extension of the authority of those hospitals to exceed their licensed bed capacity, and for the critical access hospitals to keep patients longer than the 96 hours that they are limited to by state statute, again, because if we have a surge, we want to be able to address those issues. Also being able to use alternative space that's not generally patient space, but should we need it, to use it as patient space if we get too many people and we need to spread people out. Extension of those telemedicine flexibilities. What we found was that our hospitals oftentimes, if they needed more physicians, telemedicine was a great way to get physicians in. Also, some changes to the emergency licensure for physicians in order to get physicians quickly from one state to another, should they need to come in and work at one of our hospitals because they were being overwhelmed. So those are the bulk of the changes in that, and we certainly appreciate your time, and we're happy to answer any questions should you have them.
Any questions, committee? Representative Wheeler.
Thank you, Mr. Chair, and thank you, Audrey. And you mentioned, if I understood you, alternate space that's normally not used for, is that contemplated to be within your hospital institutions or off-site?
Both. In fact, depending, because one of the things as we looked at COVID coming in, a lot of our hospitals were looking at their space. Where can we quarantine people? Where can we put our COVID patients away from our other patients? Some of them did go back and refit spaces to negative air pressure spaces to protect people, but some of those decisions may have to be made on the fly should there be a real surge. So maybe spaces they maybe are using for storage now, but they can use it for a patient care space if they readjust things.
Is that clear within this bill?
Yes, I believe so.
Thank you very much. Thank you, Mr. Chair.
Any further questions? Representative Humphries.
Thank you, Mr. Chair. So I'm curious on some of these, the ones that you mentioned about admitting patients in excess of beds or whatnot. And then it says not be required to receive prior authorization to admit patients. Who would you be receiving prior authorization from usually if we weren't doing this?
Oh, to exceed the bed space, that would be from KDHE.
And that would be true of some of these other regulations also? So are these rules and regulations or are they statutes? I mean, it seems funny to me that we're amending these things when it seems like that would be under one of the agencies.
Right. What this is really doing is taking, Mr. Chairman, what we saw in the executive orders and putting them into statute so they are extended through that March of 2022 in order to make sure that we don't get caught up in any process in trying to get new executive orders if we don't have a statewide emergency, but we start to see a surge in, say, Southwest Kansas. That if we need to respond quickly, that we are able to do that and to serve Kansans very quickly and have that freedom to do so.
Okay, so we're now putting it in statute.
Yes, but just for that limited amount of time. So you're right, we do have regulations that exist and statutes that exist on this, and this is a waiver through March of 2022 to help us deal with COVID. We hope that we don't have to use any of this. And it looks like that's going to be the case, but it's sort of hope for the best and plan for the worst sort of situation for us.
Okay, thank you. Thank you, Mr. Chairman.
Any further questions? Do not see any. Thank you, Audrey.
Thank you.
Committee, you have written proponent testimony from the American Property Casualty Insurance Company, Kansas Grain and Feed Association, Kansas Agribusiness Retailers Association, and Renew Kansas Biofuels Association. Anyone else online or in person that's a proponent? Anyone neutral? Okay, committee, as opponents, we have written opponent testimony from the Kansas Trial Lawyers Association, AFL-CIO, and Working Kansas Alliance. Any other opponents? Seeing anyone, I'll close the hearing on Senate Bill 283. We'll now move on to Senate Bill 106 and back to Natalie.
Thank you, Mr. Chairman. Senate Bill 106 enacts the revised Uniform Law on Notarial Acts, and it repeals the Uniform Law on Notarial Acts. It also repeals some other provisions related to notaries, public, in Article 1 of Chapter 53. Section 1 names the act. Section 2 provides definitions to be used. Section 3 provides for the prospective application of that act on and after January 1 of 2022. Section 4 lists all the acts that a notarial officer may perform. Section 5 requires a notarial officer to determine the identity of an individual who appears before them. And it also requires notaries to certify and attest a copy of a record to determine that the copy is a true and accurate transcription or reproduction of that original record. Section 6 requires that if a notarial act relates to a statement made in or a signature executed on a record, then the individual making the statement shall appear personally before that notarial officer. Section 7 provides that a notarial officer has who has personal knowledge of the identity of an individual if they personally are known to that officer. And it also provides other ways to identify individuals and how their identity can be proven. Section 8 provides reasons a notarial officer might refuse to perform a notarial act. Section 9 contains rules to use when the individual is physically unable to sign a record. Section 10 lists the people who can perform notarial acts. Section 11 provides circumstances under which a notarial act performed in another state has the same effect as if it were performed in this state. Section 12 provides circumstances under which a notarial act performed in the jurisdiction of a federally recognized Indian tribe has the same effect as if it had been performed here. Section 13 provides circumstances under which a notarial act performed under federal law has the same effect as it would if it were performed here. Section 14 provides circumstances under which a notarial act performed in a foreign state has the effect as if so in another country. Section 15 allows for remotely located individuals to comply with the personal appearance requirement by using a communication technology to appear before that notary. The section also lists the circumstances under which a notary located in the state can perform a notarial act using that type of communication technology. Relevant definitions there for just this one section are included here in subsection G. Section 16 requires a notarial act to be evidenced by a certificate, and it contains the requirements for that certificate. Section 17 requires the secretary to adopt rules and regulations, including a short form of the certificate that is to be used. Section 18 provides the requirements of the official stamp used by the notary. Section 19 makes a notary public responsible for the security of their stamp. If that stamp gets lost or stolen, then they have to notify the Secretary of State. Section 20 requires a notary to maintain a journal chronicling all their notarial acts, and then it provides the retention policy related to that and the contents that have to be kept in that journal. Section 21 contains guidelines to follow when performing notarial acts of electronic records. Section 22 governs the application process for a notary public and provides for registration by the Secretary of State. Section 23 requires that notary to pass an examination, and it also requires the Secretary of State to regularly offer that examination. Section 24 provides reasons the Secretary of State can refuse a license, suspend a license, revoke a license of a notary public. Section 25 provides what acts a commission as a notary public does not authorize you to perform. Section 26 provides that failure to perform a duty or meet a requirement of the act does not invalidate a notarial act, except there are some certain exceptions to that in Section 25. Section 27 requires the Secretary of State to adopt rules and regulations. Section 28 provides that a commission as a notary public that is in effect on the effective date of this act, which is January 1, 2022, continues until its expiration date. And then a person who applies after that would be required to comply with this act. A notary public performing notarial acts after the effective date shall comply with this act. Section 29 provides that this act doesn't affect the validity of a notarial act that's performed before it becomes effective. A cause of action that accrues before January 1 of 2022 will be governed under the old provisions. And then Section 30 provides for consideration to be given to the need to promote uniformity in the laws, standard provision, and uniform acts. And Section 31 describes the extent to which the act impacts electronic signatures in Global and National Commerce Act. Section 32 amends KSA 1611 to remove the authority for the Secretary of State to adopt rules and regulations for electronic notarization. Now those things are being folded into the Uniform Act. Sections 33 through 31 amend a variety of statutes to update the reference to the old Uniform Act to the new Uniform Act. And then Section 42 amends KSA 584403 to conform the electronic signature requirements to this act. The section requiring the secretary to adopt rules and regulations would go into effect on July 1 of 2021, and then everything else would go into effect on July 1 of 2022. And I can take any questions.
Thank you, Natalie. While you catch your breath and get a drink, I'm going to practice my mind reading skills. Okay. Representative Carmichael is thinking, have we seen this bill before?
Yes, you have. I'm trying to remember the number, though. I don't know why I didn't look that up before this hearing started.
Mr. Chairman, I can look it up myself.
Okay.
Don't stress the revisor, but I do have other questions about the bill.
Okay, other questions for Natalie? Representative Carmichael.
Thank you, Mr. Chairman. Ms. Scott, there are multiple provisions in this bill that require the Secretary of State to adopt rules and regulations, and I'm not clear how the process works, because I think we're repealing some of the previous actions of the Secretary and regulations under the prior statute, I think. And my more important question is there a date by which the Secretary of State must accomplish these tasks? And should he fail, refuse, or delay in performing those duties, what is the consequence about the operation of the law?
Mr. Chairman, and Bob actually just sparked me that last year's bill is 2713. So the rules and regulation provisions, there are some that are being removed. Those are mostly to deal with the procedures that we have in current law for electronic notarization. So because those provisions are being repealed and collapsed into this Notary Act, they don't need separate rule and reg authority for that electronic notarization process. There is no date by which they are required to have rules and regs in place, but that section allowing for rules and regs is going into effect a year before the act becomes effective. So I think that the intent there is to give them time to have their rules and regulations in place. As far as penalties for if they weren't to do rules and regulations, there are some things that are definitely required to be in those rules and regulations to carry out the purpose of the act. And so just like any rules and regulations, if they failed to do that, I mean, you would have maybe the option to bring a mandamus action or something like that if they weren't carrying out the law.
First, express my appreciation to Mr. Gallimore for saving me the research time. I appreciate his good work. My question, though, wasn't really directed to what penalties might be imposed upon the Secretary of State, because his office knows full well that he can be sued in mandamus. But unfortunately, he has a bad record of not promulgating regulations in a timely manner. And so if he should fail to promulgate the regulations by the deadline, and we've already repealed the regulations and the law for the existing electronic notarization, will we have a notary statute that is in effect if the Secretary of State follows his past practice of delaying implementation, in my judgment, to frustrate the legislative purpose? Will we have a notary law if he just says, I'm just not going to do it until somebody sues me?
Mr. Chairman, so the law with respect to notary is going to be in this statute. There are some things, I believe, that in order for the law to work properly, they're going to have to be in rules and regulations. So, you know, I understand what you mean by that. For example, the journal that they have to keep and the stamp requirements and things like that. But there isn't a date certain for which they have to have those rules and regulations adopted. But of course, if anyone was, you know, denied the ability to become a notary because there were no rules and regulations in effect obviously they would have a cause of action, but.
And Ms. Scott, I appreciate your answer and your discretion in avoiding political questions and providing us with what the Black law says. Thank you.
Any other questions for Natalie? We will move on to proponents. First up is Sean Miller. Or do you prefer Chris go? Chris, St. John's up first.
Chairman Patton and members of the committee, my name is Chris St. John. I am the legislative co-chairman of the Kansas Land Title Association. The KLTA's represented abstractors and title insurance agents in the great state of Kansas since 1907. KLTA supports Senate Bill 106, a version of the 2018 revised uniform law on notary acts tailored for Kansas. KLTA patiently monitored legislation across the United States over the past 5 years as other states attempted to adopt and implement technology-driven notarizations. The Uniform Law Commission had the benefit of learning from some of the challenges faced by early adopters in crafting their 2018 revision and were able to include provisions for what is becoming a new industry norm. KLTA's goal in supporting this bill is to work in partnership with interested parties in the industry, especially the Kansas Secretary of State's office, who must administer the law, to bring notarizations via two-way audio-video technology, also referred to as online notaries or RON, to Kansas in a safe and responsible way. Crossover of membership between the KLTA Legislative Committee and the Title Standards Committee of the Kansas Bar Association made the KBA an important partner as well. Title insurers ensure, among other things, the validity of an acknowledgement on recorded documents. That is why our industry has such a huge interest in good legislation on this matter. KLTA believes the provisions of Senate Bill 106 for notarizations via two-way audio-video technology are robust, safe, and secure, platform neutral, and they provide the Secretary of State with a realistic mandate to promulgate rules and regulations to incorporate as necessary many of the national data and security standards that have been produced by the national standards groups. We appreciate the cooperation and leadership the Secretary of State's office has provided, as well as the advice and assistance provided by Professor Concannon and the Kansas Bar Association in crafting this bill. For the reasons stated above, the Kansas Land Title Association supports Senate Bill 106 and would encourage the committee to recommend this bill favorable for passage. Thank you for this opportunity to testify before you today.
Thank you. Committee, any questions? Representative Carmichael.
Thank you, Mr. Chairman. And recalling the testimony from last year of Mr. Concannon, or excuse me, Dean or Professor Concannon and his colleagues from the Uniform Commission, or the Commission on State Laws, I also want to express my appreciation to Dean Concannon for his good work. Was there a reason that in preparing this legislation, the Land Title Association did not see it necessary to provide a date by which the Secretary of State must promulgate these regulations? And the second part of the question, in the interest of time, is, well, what will be the consequence if the Secretary of State decides, as he has in the past, that he will delay adopting regulations so that laws don't take effect?
Well, that's a good question. As I understood, the rules and regs were supposed to actually originally been done by 2023, and that got moved to 2022. And as far as the Secretary of State, I would have to refer that to him.
Okay, well, I must misunderstand the bill then, because I thought that there were effective dates provided for the bill but no date by which the Secretary of State must fulfill his duty. Do I misunderstand?
I think you understand that correct, Representative Carmichael. Sean Miller, he's appears as though he has some answers to your
Okay.
question, so if we can hold
Let me
those
withdraw
for
my question.
Sean.
Thank you, Mr. Chair.
Perfect. Representative Humphreys.
Thank you, Mr. Chairman. So you mentioned in your testimony that you had the flow chart, that you attached a simple flow
Is that
chart.
not attached to yours?
I'm not seeing it. Is anyone else finding that?
Okay.
We will, yeah, I don't see it attached to what Kathy sent us, so we'll make sure and find it and get it sent out.
Thank you.
Any other questions? Thank you, Chris.
Thanks.
Sean, you want to go next? Okay, Sean Miller.
Thank you, Chairman Patton, members of the committee. My name is Sean Miller, representing the Kansas Land Title Association, and I appreciate the little two-step there. The intent was for Mr. St. John to give you the why and for me to hopefully give you the how. And I knew that possibly the ranking member and revisor staff would steal my thunder on, yes, you have in fact seen this bill before, but the chairman beat them both to it. This was House Bill 2713 from last year. And I apologize, Representative Humphreys, if I didn't get that flow chart attached. It would have been the same one on 2713 from last year, so I'll get that updated. The how and how we got here today, we began working in the fall of 2019 on this remote notary law. And the revisor gave a great explanation of the bill. This is what we would, historically call a repeal and replace. So sections 1 through 14 are mostly in current law now, and we're just going to recodify them as part of this uniform law. Kansas actually passed the Uniform Law on Notarial Acts in 1984. And from 1984 until now, we have made some piecemeal changes to them, but no wholesale recodification as technology and acts have changed. And so that was the intent here. In 2011, Virginia was the first state to pass a remote notary law. We sort of tried to watch, learn a little bit, and then in 2018, the Uniform Law Commission came out with their comprehensive revised Uniform Law and Notarial Acts that included remote notarization. So at that point, we began working with Dean Kincannon, the ULC staff, the Secretary of State, the bankers, the credit unions, the realtors, Register of Deeds, to begin to put together this piece of legislation. We introduced it last year. And this House passed 2713 last year by a vote of 122-3. We went over to the Senate, and between the time the House bill passed and we got to Senate committee, as is often the case, some pings must have gone off on some vote trackers and some national organizations, and they came to us and said there's a couple of tweaks that we need to make here. You may remember from testimony last year, we had a question or two about whether our language appropriately implemented full faith and credit from the other jurisdictions who were doing notarizations. And in addition to that, the ABA advisor to ULC said the language on official stamp is not quite right. Some states use stamp, some states use seal, as we're moving to an electronic stamp. And many of the the international notarizations use the term seal, and so we had to change the language on that a little bit. Between the time it passed the House and we got a hearing in the Senate, we all met again together. We came up with language that was acceptable to everybody on that. The Senate committee adopted that, and then as so many things did in the 2020 legislative session, we ran out of time. It was scheduled to be worked on Friday. You guys went to floor all day on Thursday, and it was left there. As somewhat of a follow-up to that, we did reach out to the Secretary of State's office and to the governor's office. As COVID, it became apparent that this was not going to be a 2-week, 3-week. Here we are, a little over a year into the official pandemic. And we said we're going to have to find some way to do some of these notarizations remotely, even absent official statutory authority to do so. So the governor issued EO 20-20 at the time, and that has been reauthorized a couple of times as the emergency declaration has been reauthorized. That was, I want to be really clear, a short-term fix. That was not an emergency action that does everything that's in 106. That simply waives the in-person notification. We had a few concerns with that, notably whether or not, as a bankruptcy came down, whether these notarizations would be challenged. And so in the special session last year in House Bill 2016, the legislature put in a section that said, basically, we validate any notarization that's done under the emergency authorization in EO 2020 and subsequent executive orders. And so that was a really nice placeholder and a stopgap, but it does not provide the full breadth nor the rule and reg authority needed to fully implement this electronic act. As we talked last year, and I think even with a few members of the committee, I shared a video from a particular vendor. That's why I don't ever send it to everyone, because I'm not pushing vendors, but it's a really good walkthrough of how the process takes place. It has to be two-way audio and video. There is some multi-factor authentication that has to take place before you even get to that connection. And then there has to be log keeping, because they have to keep those video records the same way that you would have to keep your current notary logs. So those things have to be there in case they needed to be examined at a later date. And so we worked again this year. We went back through the process again to make sure there weren't any significant changes now that we do have at least some experience with non-face-to-face notarizations due to COVID. And ultimately, it was determined that we had gotten it right when we made the final tweaks in the Senate last year. And given that they were the ones that had adopted the final version, we introduced it in the Senate this year. I'm a little bit of a dinosaur in that I don't typically introduce the same bill in both houses. I know that's sort of becoming more and more common practice, but it's not usually how we did it. So there is no House companion to this bill, just to let you know that. So we worked 106 through the committee. There were no changes in the committee. On the Senate floor, the Senate Committee of the Whole and a member of the Joint Committee on Rules and Regulations that serves with the ranking member here in this committee suggested that 2023 was too long. Originally in the bill, we gave rule and reg promulgation authority beginning July 1st of this year, statute book, and it had to be the effect, or the act became effective on 1/1 of 23. So they had 18 months to promulgate rules and regs. That was carried by, at the request of another member, by Chairwoman Warren on the Senate floor to move that effective date up to 1/1 of 22, effectively moving that forward a full year. So I have 6 months to promulgate rules and regs. I believe in the testimony, you'll see the written testimony today in discussions we've had with the Secretary of State's office, they believe that they can do that. To sort of answer one of the questions that was asked previously, there is not a specific date in this bill by which rules and regs must be promulgated. I think the reviser was correct in the fact that there needs to be rules and regs promulgated in order to effectively implement this act. We have worked with the Secretary of State for about 1.5 years on this. We know that they have really reached out for best practices in other states that have adopted remote notary provisions and the uniform law in this particular case. And so they are not beginning from scratch. They have a lot of history from other states on what has worked and what has not worked. And we feel confident that they can do that. They've worked as good partners throughout this entire process. And so while I do not speak for them, I do not have concerns today that they will not implement those particular rules and regs. So at that time, I really just sort of wanted to give you the how we got here today, and I think that's it. I'm happy to stand for questions at the appropriate time. I will point out, and I did in the Senate, you know, this is a 33-page bill, I believe. Section 15, that starts on page 6, is really sort of the peanut of the bill. That is the remote online notary provision. That is the major change within this law. And then frankly, the last 12 to 15 pages of it is an amendment that this committee actually made last year when the reviser said, Sean gave me language, I did it. I realized that these sections are cross-referenced in about 30 other places, and we got to go make all those cross-references. So your committee adopted those changes, and we just incorporated it as a brand new bill this year. So I'm happy to stand for questions at the appropriate time. And if I can't answer them today, certainly dig for an answer and get back to the committee as appropriate.
Any questions, committee? Representative Humphreys.
Sorry, Mr. Chairman. Okay, I'm just going to take, like, for instance, section 20, and that's about the notary public shall maintain a journal. And it's very specific and what needs to be in the journal. And I'm kind of relating it to the whole thing having to do with these rules and regs by the Secretary of State. It seems like the regulation, the statute is clear on what needs to be done. And so how would the rules and regulations of the Secretary of State be different for instance, and how do those two things go together? And I'm assuming we don't need to wait, like, I'm a notary, I'm assuming I don't need to wait until I get those rules and regs to comply with the statute. And how do the people know, how do the notaries know all of this?
Thank you, Mr. Chairman. Thank you, Representative Humphries. So two things that I would say there. The statute is relatively specific in what has to be kept, but the rules and regs are really going to flesh out on what types of technologies they can use to keep that. So as we get into the IT world and we get way over my head really quickly, there are data formats, security types. Those are going to be the types of things that I don't think we want to spell out in statute because they may change over time as we learn that, there's a security concern in one particular data type or they upgrade to a new data type. We don't want to have to come back and change the statute every time. That's why we have that rule and reg authority to allow them to implement. In terms of waiting until, I probably skipped over one thing there in my explanation, and that is, so you heard the revisor state that nothing in this act will change any notary's authority between now and 1/1/22, so that's all correct. But there will be, so two clarifications to make, I guess. Number one, there'll be a separate notary application for notaries who want to do remote notaries. So number one, if you are a current paper and ink notary and you want to stay a paper and ink notary, you can stay a paper and ink notary. Nothing in this would require you to do remote notarizations if you didn't want to, didn't feel comfortable, whatever it is. But should you choose to do remote notaries, there will in fact be a separate license. And so, yes, you would have to wait until the effective date of this act at least to apply for that, and the application procedures for that and the $25 fee are listed in Senate Bill 106. So thank you for bringing me back to that.
Mr. Chairman.
Representative Carmichael.
Thank you, Mr. Chairman. Mr. Miller, I greatly appreciate your very helpful testimony. It reminded me of a lot of what we discussed a year or so ago, and I appreciate your explanation of the steps that have been taken since we last saw this bill to improve the legislation. And as far as a date by which the Secretary of State has to perform his duty, if the proponents don't care about that, I'm not going to stand in the way of this legislation over that issue. But I guess the bottom line of it all is I just want to express my appreciation to everybody involved in this process, because having watched the video you provided last year, this is a really good thing and it's a good idea, and I appreciate everyone who's been involved in the effort to make it happen. And finally, I appreciate dinosaurs like you who don't introduce the same bill in both houses. We've got plenty of things to do on our docket, and it's very helpful to have the wisdom of the Senate before we consider legislation like this. Thank you for your work, and thank you for your indulgence, Mr. Chair.
Any further questions? Thank you, Sean. Next, we have Mark Toom.
Mr. Chairman, members of the committee, thanks for the opportunity to appear before the committee today in support of Senate Bill 106. I'll be brief. My name is Mark Toom. I'm with the Kansas Association of Realtors, and I'll focus on remote online notary services. And during the early stages of the pandemic, no other really topic besides maybe having our industry being designated essential generated more membership calls than this topic. And certainly as Kansans begin to limit their in-person interactions, those seeking notary services were starting to demand solutions that met the needs of the new normal. We worked with the partners, many of which have already spoken, to generate the Executive Order 2020, and we're very appreciative of that, and we concur that that is definitely a short-term solution, but we need a long-term solution here, and I think that's what this legislation does. Kansas is now, I think, one of 48 states that either have a legislative solution or are operating under some sort of an executive order that allows remote online notary services. So I think we have a solution here, and I think we urge your support for this legislation and would be happy to answer any questions at the appropriate time.
Very good. Questions? Do not see any. Thank you. Committee, we have written proponent testimony from the Bar Association, from the Secretary of State's office, from Heartland Credit Union Association, from Zillow, and from the Uniform Law Commission. Is there anyone else as a proponent online or in person? Not seeing any, we'll move on to neutral testimony, and we have Ronald Smith with us today.
I'm not very used to using these masks out where I'm from. I'm sorry. My name's Ron Smith. I'm an attorney in Larned, Kansas, with the firm of Smith, Burnett, and Hagerman. It's a small firm, two of us. My senior partner, Glee Smith, was, for 15 years, was the president of the Kansas Senate back in the 60s. He also, for 20-some years, was a part of the American Bar Association and also on the Uniform Laws Commission. He is probably rolling in his grave right now that I'm down here speaking on a uniform law, but I am not here as an opponent. I do not oppose any part of the bill, and it's not my intent to hold it up in any way. All I would like to see is an amendment to Section 41 that incorporates about a dozen words at the bottom, and it's right there in your written testimony on the first page. What that allows is in deeds, acknowledgments of matters that go into the Register of Deeds office, non-production affidavits in the oil and gas industry, things of that nature, that you would be allowed to use what is current law, in my judgment, KSA 53601. You're allowed to use an unsworn declaration rather than a notary. Now, that act does not diminish the need for the bill that you have in front of you dealing with notaries. All that my amendment does is allow the law that was enacted in 1989 in this legislature to be used the way it was intended. There are several rules of construction that the Supreme Court uses to interpret rules enacted by the legislature, and one of them is quoted to you there. It's presumed that the legislature does not intend to enact useless or meaningless legislation. I was the lobbyist for the state bar in 1989 when we enacted the Uniform Laws Act. And we thought at that time that it was going to be used in lieu of notary acknowledgments in all these other documents. They made 3 exceptions to the Uniform or the Unsworn Declarations Act. One of them was, and those are on the last page of my handout, is the actual KSA 53601. Oaths of office, oaths required to be taken before specified officials other than a notary. And that's somebody like at a deposition, the person taking the deposition swears you in as a deponent. And then the third one is the oath of a testator or witnesses for wills, trusts, codicils, and amendments to wills, which makes sense, I think. You're talking about a testamentary document, which is a little bit different than a deed. The thing what an unsworn declaration looks like, at least one that's a little bit more ballooned than what's in the statute, is there on my third page, and that's that it's fairly, but you can see that it tells the person who's signing it believes themselves to be under oath and under penalty of perjury is signing that what goes before them and that signature is true and correct. That in essence is what a notary signs, that she or he has sworn in the person and signs that that's what they did. Well, what the unsworn declaration does is allow that to be done by the affiant rather than a separate notary. The Register of Deeds folks are concerned, at least mine, when I talk to them out in my area of the state, They're concerned that they want an original document to be signed so that that's what they photocopy that goes into the Register of Deeds records. Well, that's fine. You can get an original document by using blue ink. And it doesn't matter whether the blue ink is on the notary stamp. I'm a notary and I stamp my notary with blue ink. I have the stamp is blue. And so you can create an original document for filing in the Register of Deeds office without necessarily having the notary stamp on it. You can do it with an unsworn declaration. There's no reason you can't do it that way. I have been cited in the past when I bring this up to folks to some very old law that certainly exceeds 1989. I think that the law in 1989 kind of should be looked at as the newest law and the newest law having the most effect. But we certainly don't get that. I get cited to a 1973 Attorney General's opinion. And I would think that that being before computers, I think that Attorney General's opinion is not very well cited. And I would point out to you in my testimony, and I'll let you all read that you can sign electronic documents. And in fact, the notary part of this bill is contemplating signing notaries with electronic signatures. But I mean, I can sign documents electronically that invest hundreds of thousands of dollars in investments and buy stocks and bonds and do it all over the internet. I don't have to get a notary to do that. And I can't imagine why a deed on a little $40,000 house would be more important than your ability to make a multi-$100,000 investment. You can even start, as that's my understanding, you can start some criminal matters with a testimony, I think, of the police officer with an unsworn declaration. You don't have to get it notarized anymore. Used to, you did, but not anymore. The only time I've seen where a notary's signature was questioned was whether or not she actually swore in the affiant. Had nothing to do with the validity of the document or the fact that the document was filed with a Register of Deeds. It had to deal with the truth and veracity of the person that signed the deed. And the notary, by having to testify as to whether or not she swore him in under oath before he signed the document, was actually testifying as to whether she was there when he signed the document, which you're supposed to do if you're a notary. That's the only place I've seen it. You'll recall a couple of decades ago, the posse comitatus was very busy in the state of Kansas. And in fact, one of the first cases I handled out in Larned was a county commissioner had somebody file a deed against his house. And we had to use that special legislative authority that's in the statutes to remove a bogus deed. But again, the notary didn't stop that bogus deed from being filed. So, you know, that's the thing about it. We thought in 1989, the uniform or the unsworn declaration would be used far and wide on real estate matters, real estate interests, but it hasn't been. And let me suggest to you quickly how I would use the unsworn declarations, and I do use obviously notary declarations as well, but in Western Kansas, the distance between clients and lawyers is getting to be greater. And that basically means not only are there fewer Western Kansans, but there are fewer lawyers out there. As lawyers retire, we're not seeing as many lawyers come out to Western Kansas where they could earn a very good living, but they're just not coming. And I won't get into why and why not, but so you're having clients that have a greater distance. I sometimes, if I know my client is in a house, in a farmhouse out in the country, and and it's a chore for an elderly woman to get to town to find a notary and then come to town and find that the notary is working from home because she's the COVID virus or that sort of thing. It's much easier for me to send the deed to her, have her sign it, have her sign the unsworn declaration, send it back to me in a self-addressed envelope. She doesn't have to leave the house. That's something that we can do for our clients. I would use it with shut-ins, with people on rural farmsteads, people in nursing homes. And if there was a question about competency of a person signing a document, then I would ask someone to witness the signing and then give me an affidavit that, yes, she was competent. And so we would get some authority that way. Out-of-state deeds, sometimes, if you send those of you who practice, if you send a deed to California, you may have a one-page document, but you're going to get 2 or 3 pages back. They'll sign it, and then the notary in California puts at least 1, maybe 2 pages on it. Well, that triples the cost of the filing of that deed. I would use the single page with the unsworn declaration. I represent a couple of small towns in Kansas, and we sometimes get into these blighted building cases where we're trying to get title to a piece of property that's blighted, and we find the person who owns the property living out of town. It's much easier to get a quitclaim deed from them with an unsworn declaration where they don't have to go chase down a notary and send it back in a self-addressed envelope. It's much easier to start the process that way than it is through the more heavy-handed way you have to do it if you can't get the cooperation of an owner of the property. And with that, Mr. Chairman, I'll stand for questions. I appreciate your all's attention.
Absolutely. Representative Carmichael.
Thank you, Mr. Chairman. Ms. Smith, I want to really express my appreciation to you. It's a pleasure to see a practicing lawyer who will take time out of his hourly rate practice of the law to hit the long and dusty trail to Topeka and back to Larned to try to help us. And I want to express to you my personal appreciation for your effort. Also, just as a brief aside, with the chair's permission, is Bruce Gatterman still on the bench out there?
He is indeed. Yes.
Well, I thought he was near retirement age, and he was always kind to a young Sedgwick County lawyer who was in Pawnee County poaching business. And should you see him, tell him that John Carmichael said hello.
I will be glad to.
I have read your testimony here, and I think I recognize the problem that you described, because I recall when 601, I'm terrible with statute numbers, but when the unsworn declaration statute came into effect, and I thought this would be a wonderful thing because it would save a lot of running back and forth, which for the most part was pro forma in what was being done anyway. The problem that I encountered was, though, I think something similar to what you described, that even though the law provided for the use of these unsworn declarations, some filing officials would not accept it, or other folks would question the validity of the document. And I thought that had all pretty much gone away. But I guess are you here to tell us that the law as we have it is sufficient, but it's not being followed? Or is there truly a substantive change in the law that need to be made?
I don't think it's a substantive change. I think as the amendment reads, all we're saying is you can have a real estate document acknowledged as long as you follow what's in 53601.
Right.
And it doesn't change anything other than the fact it's in addition to the ability to file a notarized deed.
My understanding was, though, that 53601 by its terms actually would apply to the types of documents you describe, except for the 3 or 4 excluded categories, which are for good reason. And what I'm trying to figure out here is, are we putting this in here because the law really doesn't cover this, or are we putting this in here so that once again, one can point to a statute that says you shall file this deed based upon an unsworn declaration, even though that's already the law?
It's already the law, but what I'm requesting you do is in this law, section 41, that you put another dozen words in there to remind people what the law was in 1989.
Yeah. And part of the reason that I asked the question is there is a general doctrine in the law that says when the legislature makes an enactment, they intend to somehow modify or change that we don't do needless acts here. And I know many
That's right.
could argue that. And I just want to make sure as they're recording, literally recording what we're saying here, and it's saved for posterity. And I want to make sure that your intent is the same as my intent. And that is say, we don't think we're changing the law, but we just want to make it abundantly clear that the unsworn affidavit law applies to the types of documents that you're describing.
Right. Section 41 applies to real estate, and that's what we're looking at. Yeah.
Okay. Again, I appreciate your efforts in being here. Thank you so much. Thank you, Mr.
Right.
Chair.
Any other questions, committee? Not see any. Thank you very much.
Thank you all.
Anyone else as a neutral conferee? Are there any opponents? Okay, we'll close the hearing on Senate Bill 106. Committee, we've got lots of time. Let's start working. Let's do Senate Bill 103. Natalie?
Thank you, Mr. Chairman. Senate Bill 103 makes changes to the Kansas Power of Attorney Act regarding that form that it has to be on, requiring the Judicial Council to make that form, and then requiring acceptance of a power of attorney that's on that form, except for in certain circumstances. And it also makes some changes to the duties of third parties when accepting those power of attorney forms. And I can take any questions.
Are there any questions for Natalie? Are there any amendments? Not seeing any. I have one. I'm not sure I like the effective date, so if we could move it from the publication in the statute book to instead publication in the register, I think that'd be better for all of us. Is there a second by Representative Hoheisel? Oh, was that a second though?
Second, yeah.
Okay, second. Discussion on the amendment.
Mr. Chair? What's wrong with the effective date?
I don't know. There's just something about it, and I'm guessing I'm going to have it for the next 3 bills as well. Same concern.
I hate it when that happens. Thank you, Mr. Chair.
Any further discussion on the amendment? Not seeing any. All in favor say aye. All opposed say no. Motion carries. For the new guy, I'm trying to make these bills conferenceable, so I'm just changing something so we get to the Senate and we have the opportunity to discuss it with the Senate in the event we need to package some things together. So we have to change it a little bit. Yeah, right? Okay. Any other amendments? Not seeing any. Is there a motion concerning Senate Bill 103 as amended? Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out Senate Bill 103 as amended.
Is there a second? Representative Jennings. Any discussion? Representative Hoheisel, you may close.
Close.
You've heard the motion. All in favor say aye.
Aye.
All opposed say no. Motion carries. The affirmative votes wanting to be recorded. Representative Owens, Hoheisel, Heiberger, Carmichael. And I can't see my list, but I'm betting we have, hold on one second. Oh, Hobson out there somewhere. Is he out there? I'm sure he's out there. We'll put him, there we go. Okay. Now let's do Senate Bill 107. Back to Natalie.
Thank you, Mr. Chairman. Senate Bill 107 enacts the Uniform Fiduciary Income and Principal Act, UFIPA, and repeals the previous act. And I can take any questions.
Any questions for Natalie? Representative Hoheisel.
Thank you, Mr. Chair. Hey, Natalie, how long is this bill?
Mr. Chairman, this bill is 37 pages.
And what is the effective date on this?
Statute book.
Okay, that doesn't sound right. All right, thank you, Mr. Chair.
That does not sound right. So I think I will propose an amendment to change it from the statute book to publication in the register. Seconded by Representative Jennings. Any discussion? Representative
Yes,
Carmichael.
Mr. Chairman. I rise in strong opposition to this amendment, Mr. Chairman. I spent 13 days conferencing with the Senate Judiciary Committee, and it has strained my mind beyond the point that I can endure any more conference committees with our colleagues from the Senate. So I hope that my strong objection is noted by your committee. Thank you, sir.
Any further discussion? Okay, you do have discussion, Representative Owens.
I just wanted to rise in support of this amendment because I thoroughly enjoy when the good representative from Sedgwick has to suffer at the hands of the Senate Judiciary. So thank you, Mr. Chairman.
Okay, not seeing any further discussion. All in favor of the amendment say aye.
Aye.
All opposed say no. Motion carries. Any further amendments? Is there a motion? Representative Heiberger.
I just want to observe the phenomenon that the longer the bill is, the shorter the discussion is in general. Just there's a direct inverse relationship.
Well, Representative Humphreys was all ready to second your motion, and I don't think that wasn't a motion, was it?
Move that the House pass out Senate Bill 107 as amended favorably.
There we go. Motion by Representative Heiberger, second by Representative Humphreys. Any discussion? Representative Heiberger, you may close.
Close, and I strongly urge my colleagues here to vote for this motion.
For the motion, all in favor say aye.
Aye.
Opposed, say no. Motion carries. The affirmative votes floating recorded: Owens, Hoheisel, Heiberger, Carmichael, and we're going to say O'Hobbesum as well, even though we can't see him. Representative Jennings, did you want your no vote recorded? Oh, okay. So we don't need that recorded now, or Kathy. Let's do Senate Bill 58.
Thank you, Mr. Chairman. Senate Bill 58 prohibits the filing of certain liens or claims against real or personal property. It also provides some criminal penalties and prohibition on filing future liens. And I can take any questions.
Any questions for Natalie? Are any amendments? If there aren't any, I have one. I would move that we change the effective date to publication in the register. Is there a second? Second by Representative Hoheisel. Any discussion on the amendment? Seeing none, all in favor say aye.
Mr. Chair, I'm sorry.
Oh. Go ahead, Representative Carmichael.
I apologize. First, I, of course, object to this needless amendment for reasons previously stated, but I neglected to mention to Mr. Smith that we were about to hear this bill, so I hope he hadn't hit the long, dusty trail yet, because as he can see, what was once the posse comitatus are now the sovereign citizens, and some things just never seem to change. Thank you, Mr. Chair.
Okay, all in favor of the amendment say aye.
Aye.
All opposed say no. Motion carries. On the bill as amended, is there a motion? Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out Senate Bill 58 favorably as amended. Good luck picking a second.
Second by Representative Wheeler. Any discussion? Seeing none, Representative Hoheisel, you may close.
I close.
For the motion, all in favor say aye.
Aye.
All opposed say no. And the votes we want recorded: Owens, Hoheisel, Heiberger, Carmichael, O'Hobbesum. Now House Bill 2122.
Mr. Chairman, House Bill 2122 enacts the Supported Decision-Making Agreements Act. It provides a statutory framework for adults who don't want a conservatorship or a power of attorney, but need some assistance with decision-making support to enter into contracts to do that.
Any questions for Natalie? Are there any amendments? What's the pleasure of the committee on this one? Representative Owens.
Thank you, Mr. Chairman. It is, let me find my number here, 22. I move that we pass out House Bill 2122 favorably.
Is there a second? Representative Humphries. Any discussion? Representative Carmichael.
Thank you, Mr. Chairman. I do have a more serious discussion reference to this bill. As I'm sure the committee will recall during the course of the testimony on the bill, we certainly discovered that this potentially important probate-related legislation has not been to the Judicial Council, and it has not been to the KBA's probate committee. I don't have all of my notes in front of me, but the same legislation was heard last year or the year before, and I've got the notes somewhere of what it was, but there were 15 of us who voted no on similar legislation a year or two ago, in 2019, I think it was. And at the time, I voted no because probate practitioners who I know and who I practice with identified what they thought were potential problems with the legislation in the form of the supportive POA, etc. And unfortunately, I've been unable to put my hands upon what the nature of their objections were that caused me to vote no 2 years ago on this. So I'm not going to stand in the way of this, and I'm not going to move that we table this. I'm not going to yell and scream that we ought to send this to the Judicial Council to make sure that what we're doing is right, because it could have some really bad consequences if we screwed this up. Instead, I'm going to hold my peace, and I'm going to hope that I was wrong, because I can't articulate or recall the things that may be wrong with this legislation. But I certainly recommend to folks, when they put forth the effort to bring legislation of this import, that they do what the Land Title Association, the notarial acts, etc., that they get the direct consultation of bar association committees, or that they send matters to the Judicial Council and not rely in this committee on saying, well, I'm not a lawyer, but I talked to one who stayed at a Holiday Inn last night who's a good probate lawyer, and he or she says it's a good idea, and I think it is too. I really think we ought to do a better job of vetting this type of legislation. And so I hope that folks, if they're listening, will help us in that project in the future. And I see my friend Boog, who sees this differently, but this isn't the best way for us to be doing these things. Thank you, Mr. Chair.
Representative Heiberger.
Thank you, Mr. Chair, and I guess my esteemed colleague from Wichita and I do disagree on this. Yeah, as he pointed out, 15 people voted against the bill in 2019. I think it's HB 2034. 105 people voted for it. It passed out of this committee, I understand. I think we've seen it in Fed State too, if I'm not mistaken. Now, I've talked to the proponents of the bill, and they have assured me that this year, and at least twice, maybe 3 times, they have conferred with people on the Judicial Council and members of the KBA probate session, and they have no objection to it. And they, as he pointed out to me, that they don't file neutral or proponent testimony on every bill that comes before us if it's not something that they propose. So I believe that my esteemed colleague said sometime this year that he hadn't looked at our sacred probate code for several years. You know, I'm certainly not a probate expert myself, but I do some, and I don't see any problem with this bill. It doesn't allow a supporter to sign documents on behalf of the supported individual. And so in that way, I don't see how it impacts the probate process at all. I mean, I think it's my understanding that 19 states now have statutes like this, and 19 more are considering them. I appreciate my colleagues' concern about not screwing up our probate code, but I don't think this bill will do it. So thank you.
Further discussion? Representative Humphries.
Thank you. I think maybe a little history is interesting. I think it ended up, it was introduced as House Bill 2034 in Fed and State. And then it was somehow became a substitute bill in Judiciary. So it was in Fed and State that we heard it. And Boog and I both, Representative Heiberger and I both heard that. That's why it was familiar to us. And then somehow it, you know, in the transfer of everything. So that's the history. It might look like it was in Judiciary, but I think this time they thought it was better suited for Judiciary. So, yep. Okay. Just.
Thank you for that. Any other discussion?
Yes, Mr. Chairman.
Oh, yeah, Representative Carmichael.
Thank you. And Representative Humphries is correct that when this legislation was heard, I think it was in 2019, it originated in the Judiciary Committee, and the eventual bill which was passed was a victim of the conference committee process. Of the eventual bill that was passed had nothing to do with the bill that was introduced, but the vote that has been described here with 15 of us in dissent was the vote on the House floor on essentially the same bill that we see here today. And I don't think there's any distinction or difference there, but folks ought to understand, if you go look it up, you're going to find a different bill as being signed by the governor under this number. But when we talk about what the actual vote on the House floor was, we were talking about this bill. This is the bill that I voted no on. The other thing is, I do always appreciate the wisdom of my good friend and colleague from Douglas County, and I've used the word probate in far too generic and far too broad a sense. This is not actually probate law per se. It's probably closer to what most folks call now elder law, but it also deals with other people who have various types of disability. But conceptually, my concern is the same, no matter what label we put on it. This is serious legislation, and I personally don't want to answer to my colleagues by saying I put my stamp of approval on it, because I'm not wise enough in this area to know. Thank you, Mr. Chair.
Any further discussion? Representative Owens, you may close.
Thank you, Mr. Chairman. It seems like my learned colleague attorney friend know way too much about probation. So with that in mind.
And parole as well, yeah.
I had to go there. With that in mind, I close my motion.
You've heard the motion. All in favor say aye. All opposed say no. Motion carries. Affirmative votes: Owens, Hoheisel, Heiberger, Carmichael, Ohabism. Committee, we have a few more minutes.
Mr. Chair,
House
I'm
Bill
sorry.
20
I was a negative vote. I just didn't get my.
And a no vote, Kathy.
If you recall, this is the one that I don't want to put my name on. So
Got it. Representative Carmichael votes no. I'm going to have Natalie explain to us 2150. I did not have that on the list yesterday, but in thinking about it overnight, that's one we heard yesterday, and if there are no objections, we'll work it. But I certainly want you to hear an overview and have a chance to think about it, and let me know if you'd prefer we wait. But I thought it might be one we could knock out since we have 10 minutes till appropriation starts. So Natalie?
Thank you, Mr. Chairman. House Bill 2150 creates that definition of financial exploitation, so it collapses those categories, and it also requires different or more mandatory reporters of adult abuse, neglect, and exploitation. It increases the number of investigation days in the abuse, neglect, and financial exploitation of certain adults, and it also has some reporting requirements back to the regulatory agency. And I can take any questions.
Before we do questions, just a reminder, this is the committee, or this is the bill that had come out of Children and Seniors. It had gotten below the line and then sent to us just to hear it again to make sure there weren't any concerns with it. So any questions for Natalie? Is there any objection to working this bill today? Not seeing any. I'm guessing there are not any amendments since I didn't give you a heads up, but are there any amendments? Okay. Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out HB 2150 favorably.
For a second?
Second.
Second by Representative Keither. Any discussion? Representative Humphries.
I would like to hear from the committee their thoughts on the fact that it increases by quite a bit the number and the scope, the base, how many mandatory reporters there are. And, it's people engaged in postgraduate training, anyone licensed by the Board of Examiners in optometry, school administrators, other employees, firefighters. I'm surprised they're not mandatory reporters, but I wondered if anyone else had any thoughts on that, or if they've, since we just heard it, if anyone had, community corrections officers, CSOs and mediators. I mean, lots of addition to the mandatory reporters. Does anyone have any thoughts on that? Because we did not talk about it very much. That didn't come up very much.
Yeah, it did not come. I noticed it as I was reading through the information from children and seniors, but it didn't come up in committee yesterday. Anyone else have any thoughts on that? It's not any student in a postgraduate training, only those approved by the State Board of Healing Arts. So there is some connection, I think, there to those might be individuals that see this type of stuff. Representative Jennings?
Maybe a question for Natalie about this area. So Natalie, there are mandatory reporters with respect to instances of child abuse. And it looks like this list is a lot of those people. There's a couple extras. Is that pretty much the case? Do you know?
I don't know offhand, but if you give me a couple minutes, I would be able to compare those lists.
I would just say I'm shocked. She doesn't know offhand.
I know. So,
Mr. Chair, as we're looking at this, I can withdraw my motion and we can work this next week if you would like to.
I don't know that I have a huge concern. I just hated to just pass it without mentioning that it seems like a big.
I agree. I think that, I mean, I know Representative Owens has to get to appropriation. So if this needs a broader discussion, we can withdraw our motion. Just
other thoughts? I have no concern with waiting till Monday. I don't know that we can work bills Monday, but someday next week.
Mr. Chairman.
Yes, Representative Keither.
I really would prefer we just go ahead. To me, if they fall in the correct category to be a mandated reporter, I think the more the merrier for elderly or whether it's children. So I would like to see it go forward because I'd like to be able to get the attention I think it needs. Thank you, Mr. Chairman.
Representative Carmichael.
Thank you, Mr. Chairman. I want to join in Representative Keither's recommendation, and I certainly want to assure the members of the committee that if this bill makes it to the floor, and if on further reflection we find that we've included some group or category that shouldn't be there, I'll be the first one to say that it's no violation of the committee process, that it makes sense we ought to discuss it. When we talk about people in postgraduate programs from Board of Healing Arts, we're talking about, in essence, doctors who are in residency and fellowship programs. Obviously, we know about optometrists. I used to really scrutinize making mandatory reporters, but I've changed my policy because I've decided that probably the more the merrier. The more that are there, the safer it is for vulnerable populations. And I can't recall specifically in this bill, but typically by making someone a mandatory reporter, there are certain immunities, if you will, attached from defamation and the like. And so I've changed my tune completely on mandatory reporters. I think the list is a good one. Thank you.
Representative Hoheisel.
If it's okay with Representative Humphries and she doesn't object, I'll stay with my motion.
Yeah, no, I don't object. I just needed a
Yeah.
little bit of discussion about
No,
it.
it's important to point
So
that out because
Mm-hmm.
if you didn't dig into it, you wouldn't have seen that.
Yeah.
Representative Patton,
Natalie?
I do have an answer, at least a kind of answer to Representative Jennings' question. So it looks like kind of the first group of people, like the cap A through cap I, those teachers, healthcare professionals, people of that nature, those seem to be very similar to the mandatory reporter list on juvenile or abuse against children. But then the rest of them, those like bank trust officers, those type of individuals are not included. The court services, community corrections officers, they're not included on the juvenile side.
And failure to report in the case of a juvenile is what classification of crime?
It's a Class B misdemeanor.
All right, so that's the same. Thank you.
Any further discussion? Okay, Representative Hoheisel, you can close.
Thank you, Mr. Chair, and thank you, Representative Humphries, for bringing that up and engaging in that discussion. I close.
Heard the motion. All in favor, say aye.
Aye.
All opposed, say no. Motion carries. Affirmative votes to record: Owens, Hoheisel, Heiberger, O'Hobson, and Carmichael. That's it for today, committee. I don't think we will have time to work bills on Monday, but I hate to pass up any time that we do, so I'm going to give you a couple bills that we may work. Senate Bill 4, Senate Bill 106, Senate Bill 283, and House Bill 2366. Again, that may be a wish list. Tuesday, Wednesday, and maybe Thursday we'll have many more. But we'll see how Monday goes. Everybody have a great weekend. If I don't see you here tomorrow, go Shockers and then Jayhawks this weekend. So have a great weekend.